G'day, legal studies students. So I just want to have a chat about the way we use sources in legal studies. And while this goes through some basic things, it also goes through, I think, some of the really sophisticated challenges that those students who are ambitious about getting up in the A range might really think about in the way they use sources. We're thinking about analysing and evaluating information. That's the first part of it, and that's the part that everyone needs to be pretty good at. Then we're thinking about, can we make connections between the information that we found? And finally, can we create some information to create something new? Creating something new, of course, is always about different perspectives, and we talk about viewpoints specifically in the legal studies syllabus. So this is another way, a different perspective of thinking about a situation. Here's where this came from, and it was something I looked at a couple of years ago in staff professional development, and it was about this idea of synthesis. And synthesis is like a little bit of a teaching weasel word that means putting together different pieces of information and getting something out of it, creating something from that. And we do that a lot in legal studies, bringing together different pieces of information. But this article was really interesting in that it looked at what does good synthesis look like, and it created a marking scheme for students' work to say, yeah, this shows elements of good quality synthesis. So what I've done is I've pulled a lot of those bits from the marking scheme that says this is good quality synthesis to say, let's put it together and see what it means for legal studies. And synthesis, again, just remembering that it's just a weasel word that just means that we put together a bunch of sources and we make some meaning from them. And we have to do a lot of this in legal studies, putting together different sources to make meaning from them, or synthesis. We have to do it in comprehending, because we want to put together a bunch of information that looks at the different range of legal processes, concepts, and principles. We have to do it in selecting. We've got a whole criteria that looks the way we choose and use legal studies sources. And sources means things like expert opinions. It means things like the facts of cases. It means the legislation. It might mean something like a statement from a judge's ruling. All those different legal pieces of information, legal sources. Analysing encourages us to look at different viewpoints. And finally, our evaluation, when we come to that recommendation, it could well be something where we create something new from the information we've looked at, that recommendation that we finish with. I'd just like to slip back to what we did when we went to the Supreme Court Library, the fact that we looked at, or we were given a few ideas of what quality sources might look like by Kimberly, who was speaking with us there. One of them was the conversation, which she introduced as a source that often had people who are academics or on the way to becoming academics, so really people with subject expertise. The Guardian as a higher quality source of information, and the Supreme Court Library database that you can look at. It's interesting that in one of the recent subject reports for legal studies, so every year the people who oversee the subject legal studies in Queensland put together a report, and they emphasise that it's not good enough just to use a bunch of newspaper articles and expect to get to the top criteria. That's not going to be good enough from the selecting point of view, and it's probably not going to be good enough when it integrates into like different viewpoints. So we have to be thinking about using good quality sources. I suspect most of you will have seen this before, this idea of what's the quality of source mean? Is it someone as an author who is low quality, that would just be an anonymous source, through to someone who is a legal expert? And that's what we're looking for more and more. Where is it published? So is it just a blog or Wikipedia? Although when we rule out something like a blog, we've got to be very careful, because there's some very high profile people who write blogs. If someone's writing a blog from a perspective of expertise, then that has some real value. But higher quality things will look like journals or university publications, The Conversation, where articles are written by people with a great deal of subject expertise. How recent is it? There's always a bias wherever possible to use more recent information. And when you look at that article, what are the data and references that support the work? For example, if the article talks about a decrease in the crime rate, how well is that justified? Have they used a good data source themselves, like, for example, the ABS? So thinking about how well referenced the ideas are, just as you're trying to create a legal studies response with really well referenced ideas. Now, as we talk about this, one of the great shortcuts, I think, when you're looking at articles, is that in an article that is well put together is going to make use of good references themselves. And so it's often a great idea to go and see if you can find the bibliographical chain, like all those articles, the articles that have been referenced, the data that's been referenced, the legislation's been referenced. That also becomes really important information. For example, you probably used to seeing reference lists at the end of articles. All of those might be really interesting articles to link to. Have a look at the title. Is it something else that can provide a great source? I've noticed more and more legal firms, like businesses, that law firms, solicitors firms, that have increasing databases of articles that they write. And they write it because they want to show that they have expertise in a subject area. It makes people more likely to hire them. But those are good articles because they come from a basis of some expertise. But they often have links to other cases, links to the legislation, links to other articles that they might have written before. So when you're thinking about it, when you're using a high quality article, often it gives some clues as to the next place you can look for information. So next we come to this idea of using a source effectively. And I've put together a little example using the idea around the age of criminal responsibility, which has just recently become a little bit of a topic again, although we're more interested in the concept itself. It's become a topic because in the Northern Territory there's been a change of government. One of the policies of the incoming government is to make 10 the age of criminal responsibility there. So different ways you can use, and I've tried to demonstrate all of these. Direct quotes, so they emphasise specific words that come from a source. Emphasise the expertise of the author. There's no point in writing about what a judge says unless we highlight the fact that the quote has come or the comments have come from a judge. They're part of the expertise. Paraphrasing and summarising, that's putting things into your own words, and then making the main idea clear and connected to the main ideas in the paper that you're writing, the report that you're writing. So an example, Westerman 2021. So there's the in-text citation there. A researcher and psychologist, they are her expertise, says the failure to capture national data. So that's emphasising, using a direct quote to emphasise what is said there about the reasons for juvenile incarceration is outrageous and unacceptable. Another direct quote, because they're pretty powerful words, pretty strong words. And then we go into that paraphrasing, summarise, and leaves no ability to understand why young people are in jail, beyond knowing the vast majority, 84%, are in jail before they face trial. Now, I want to link this back to the main idea. This provides no support for juvenile detention as a worthwhile legal outcome. So there's one way how you can use, it's just an example of using a legal source effectively. Another thing you can do is try and find a conversation amongst sources. There's two ways you can have a conversation, is talking about two sources that disagree and having one overcome the other, or maybe finding two sources that reinforce the one perspective. So in this first example up here at the top of the page, while Smith, 2003, suggests the age of criminal responsibility be kept at 10, his view is formed at a time that does not take into account contemporary understanding of the damage incarceration can do to children, as outlined by Westerman, 2021, a psychologist and researcher. So we've put together a viewpoint, we've put Smith's viewpoint there, but then we've kind of overcome it with using a source that disagrees. We've explained why. Another one, Ian Lever, 2014, as Police Commissioner of Queensland. Actually, I'm not sure he was Police Commissioner or head of the union, but either way. Ian Lever, 2014, as Police Commissioner of Queensland, calls for the age of criminal responsibility kept at age 10. His position, however, comes from the narrow perspective of expertise in the police, where an expert on child development and well-being like Tracy Westerman, 2021, considers a range of factors, including the chances of experiencing of reoffending. So just looking at two different sources there. Two sources that you can use to reinforce one perspective. You might just put them together at the start. Stevens and Jones are in agreement that one of the key elements, and then go on to where you are. But by using two sources instead of one, you're making a slightly more powerful statement. And as we get towards the end of this, as well as the conversation sources, the last thing we might do is analyse sources to make something new. Can you put together information from different areas to draw a different thing? So, for example, we often talk, I've used this example through the paper a little bit around the age of criminal responsibility or through this presentation. So maybe you might say, well, at the end of it, rather than have the aims of punishment, which we already know exist, maybe they have to create a model for the aims of juvenile punishment. as a different example. I've then got another example at the bottom there, but I won't worry about that. Here's one that I've put together around negligence. Perhaps we've been talking about negligence, and as our society becomes more diverse, we think, is the reasonable person test too general to set the standard of behaviour in a negligence case? So maybe we build a new model. We use our synthesis, our different ideas that we've come across, our research we've done, and put together a new model that looks at different ideas. The reasonable person still, maybe the details of the situation, maybe the background of the person. We use that synthesis to put together a whole new test. So here's where we start, and here's where we get back to. So if we want to think about how we're using sources in legal studies, first of all is that idea of analysing and evaluating information. Are we using quality sources? We've got that checklist. Who's the author? When was it written? What's the link to other good quality information there? The second thing we start to think about is, are we making connection between information found? Are we finding sources that agree with each other and emphasising that? Are we finding sources that disagree and putting that together and having a conversation between those two voices that end up in a different opinion? That's quite a sophisticated thing to be doing. And lastly, are we combining new and existing information to create something new, perhaps around that legal recommendation